survey, good idea, not very expensive. You've carried out your checks, and at this point the question will arise, won't it, as to whether you should sign some preliminary purchase contract, sometimes called a private agreement to sale and purchase, or a property purchase contract. But this is a contract different from the thing you sign when you finally go to the land registry to transfer ownership. So explain about these preliminary purchase contracts.
The preliminary purchase contract is mainly used for the sale to the non-nationals, because you would expect to sign a contract. But in Turkey, if there is no a hold-up period, such as military permission, because I think we haven't covered that, but if a non-national purchasing, and if that area of plot has not a clearance before after 2012, you need to make you need to receive a clearance from the military authorities, and this may take up to 4 or 6 weeks time. So which we call as a grey period. So parties has to be waiting until that clearance are received. So
and of course, sellers don't like to wait for that.
No, they don't like.
They have no choice because it's required by law, but they don't like it because everybody wants to go on.
Correct.
The agent wants his commission, the seller wants the money, and so you've got a bit of negotiation.
So you would be expected to sign a preliminary agreement in such a case, or the second common case, if the property is not purely off plan but not finished yet. So if you need to wait for a while for individual title deeds to be granted or the licenses to be granted, if you will be waiting for a period of time, you might be asked to sign a preliminary contract.
Yes. And what is a preliminary contract?
Yes, the preliminary contract is covered by our Code of Obligations. Normally, the buyer is promising to buy the property for some certain price, and the seller is promising to sell the property for that price. And you will be detailing the property in that agreement, and you will be detailing the liabilities of the parties. And also you should just put a clause saying if one of the party terminates the agreement, what will happen. So this is the preliminary agreement. And you would normally pay a deposit across when you... Yeah, deposit. Maybe in that case it might be a little bit like a substantial amount than you
typically how much?
Like a 30% or like a 40% it could be asked. But we have to be careful about the preliminary agreement, because we have a specific rules for that type of agreement, and we call it a promissory purchase agreement. If you are doing such a deal, then you need to obviously see a lawyer, because if the contract is not complying with the rules, it's going to be invalid.
Yes.
So you will not receive any right over the property.
Yes, and if the contract is invalid, not only will you not receive any rights over the property, you could be struggling when it comes even to recovering the money you've paid.
Yeah, or if you are expecting a compensation, it is likely that you are not going to get that compensation.
So the best you would get would be the refund of your deposit.
Yeah, with some legal interest, which is not going to be really helpful.
So, from what you're saying, if you're buying a house which is already constructed, and it's a resale property, or it's a new property which is already fully completed but not yet been lived in, you really don't need one of these contracts. No. You can proceed directly to the final stage. That is
correct, because our purchase agreement is produced by the land registry.
Yes.
That is the official document.
But you'll often come under pressure to sign one of these preliminary purchase contracts, basically because it means that you pay money across more quickly to the seller and the agent.
Yeah, if you are paying a substantial amount as a deposit, or let's say first installment, because it could be like an installment payment plan, then you need to sign the preliminary contract at the notary.
Yes, and that's important, isn't it? Because if you don't sign it, if it isn't a notarized contract, then it is completely unenforceable.
Yeah, it's yes, it is unenforceable. The terms of the agreement will not be considered by the judge. The judge will only decide that this is giving lending money, so you just get your money back, and all the other terms and conditions will be invalid because the original contract is invalid.
And if you do sign the preliminary purchase contract, or we should more accurately call it the promissory purchase contract, in front of the notary, there is a notary fee to pay, which is not small, and also there's some tax to pay. Is it,
yes,
what 1% is it?
You will pay like a stamp duty and the notary fees. It is almost like a 1%.
1%.
In total, 1.2 maybe. But I just need to make a comment on this because it is not that you just get and sign the contract before a notary, because normally the contract is drafted by the notary.
Yes.
It could be drafted by your lawyer and you can just give that to the notary, but they are not just witnessing your signature. Basically, they are drafting and
checking that the contract complies with the rules.
Complies with the code,
So this is not, yes, as you say, this is not just the notary saying, I am the witness to the signature. He has a bit more to do in this case.
Yeah, exactly.
So, very important point, if you're asked to sign a promissory purchase contract or any sort of contract really, from the point where you've signed a reservation agreement all the way through to you get your title, then that document has to be signed in front of a notary.
Correct.
Otherwise it is going to be invalid.
Invalid.
Yes. Okay, very important point.